Good morning to everybody and welcome to this webinar organised by the European Lawyers Foundation and the Council of Bars and Law Societies of Europe. The topic today is latest developments in EU data protection, what European lawyers need to know. My name is Jonathan Goldsmith and I am Senior Project Counsel with the European Lawyers Foundation. We have a lot of people joining us this morning for the webinar, and so while people are entering it, I will make a number of announcements as to how it will run. We encourage questions, but please use the question and answer box, which you will find at the bottom of your screen, to put your question in English. We will try to answer all questions if time allows it at the end of each session or maybe at the end of the webinar. Please don't use the chat box for questions. You can say hello in the chat box, but the questions should go in the Q&A box. This webinar is being recorded and the recording will be available on the European Lawyers Foundation's website by the end of the day. A number of more important announcements. Unfortunately, there's been a last-minute change to our program today beyond our control. Nothing very radical, but a change in the order of the speakers shown. All the sessions are the same, but we will, after the introductory remarks, we will go to data protection and lawyers' duty of confidentiality. After that, the European Commission speaker will speak on the general introduction to latest developments in data protection, and the rest of the program will then follow. We receive a lot of questions about the next 2 points. Number one is all the presentations will be uploaded onto the Foundation's website. I've seen the presentations, they're packed with extremely useful information. Our speakers today may not have the time to go through all the detail, and so the slides will be able to be consulted on our website later today. And finally, for those looking for certificates to complete continuing legal education, we ourselves do not provide certificates. You have to approach your bar for a certificate. We provide the bar with a list of those who have participated together with your connection time. So don't ask us for the certificates, ask your bar, who will approach us for confirmation that you have attended. And so with that, we begin the webinar. It's my great pleasure to introduce the President of the Council of Bars and Law Societies of Europe, Thierry Vickers, who will make some introductory remarks. Thierry was President of the Bordeaux Court of Appeal Bar Council 2000-2001, chaired the Conférence des Bâtonniers 2004-2005, and the Conseil National des Barreaux 2009-2011, and he's one of the 3 authors of Règles de la profession d'avocat, which is in France the reference book on the organisation and deontology of the legal profession. Thierry, over to you.
Many thanks, Jonathan, and you have perfect timing since you have allowed our member to connect, and now we are more or less 500 to attend this webinar, and it's still, and again, a great success of collaboration between CCBE and the European Lawyers Foundation. As president of CCBE, I'm very pleased to welcome you for this webinar. We have a tremendous panel today to listen to, even if, as Jonathan has said, it will be not exactly in the order of the program, but anyway, I will thank those panelists to be there and to share the knowledge about this very important topic, which is data protection in Europe from the point of view, obviously, also of lawyer. So I'm sure that this webinar will be very, very interesting for all those who attend. I'm very pleased again to see the interest in that webinar as raised among lawyers, and I hope you will have, and I'm sure you will have, a very fruitful webinar. Jonathan, you can take the floor again. We are just on time to begin. Thank you very much.
Thank you very much, Thierry. And now we move on to our first session. As we have explained, it is in fact what appears on the program as the last session. It's to do with data protection and lawyers' duty of confidentiality, a very important topic. Our speaker is Dominic Gerstberger. Dominic is a lawyer from Austria who's the current chair of the CCBE's IT Law Committee and a member of the Austrian Bar's Equivalent Committee and of the CCBE's Surveillance Working Group. He lectures in civil and corporate law at the University of Linz in Austria. So, Dominic, over to you, please.
Thank you very much. A warm welcome from me as well. I will share my slides real quick. Can you see the slides, Jonathan?
Not quite. Yes, perfect. They're there. Thank you.
All right. Well, good morning, ladies and gentlemen. Thank you very much for the introduction, Jonathan. Today, as it was said, I am joining this group of data protection professionals as, you may say, the professional ethics guy. As chair of the IT Law Committee of the CCB, I am pleased to report on the hot topics currently under discussion in the professional ethics section of the IT law, particularly regarding the duty of confidentiality and data protection. Recent developments in this area are both exciting and highly relevant for our profession. Where possible, I will, of course, reference to important and, where existent, also recent case law and legislative developments. Since the IT Law Committee deals with a wide range of hot topics and your time is valuable, I have selected a few issues that I believe will capture your attention and perhaps even spark your interest. So we're totally in line with two of the four AIDA principles. And if I am also able to inspire action in the form of comments and questions afterwards, I will be even more delighted. But now enough of the intro, let's show you what I'm planning to talk about. I'm well aware that each and everybody in my today's audience has to comply to and hold high the duty of confidentiality. But maybe there is at least a few of you who have not dove deep into the legal grounds and case law behind the duty of confidentiality lately and could use a little brush up. For that reason, I would like to begin and briefly outline the key principles and legal basis of the duty of confidentiality. Afterwards, I have prepared three main topics. First of all, I will address a subject that is currently shaping our profession, of course, artificial intelligence. There is much talk about how AI might revolutionize our field or even make certain roles obsolete. I do personally not think that such a revolution will happen as quickly or as drastically as some prophecies say. But in any case, Gen AI systems also for legal purposes exist and we will have to deal with them. So rather than speculating about the future, I will focus on the risks and challenges Gen AI poses for data protection and confidentiality. In this context, I will also touch upon cloud computing, which goes often hand in hand with AI applications, even though, of course, it is not exclusive to it. Secondly, I will turn to a central issue in data protection, the right of access. I will discuss where the boundaries and the general broad right of access lie and what limitations exist in practice. And last but not least, I will report about recent developments in data retention. Even if this is on a European level not yet there, it's already happening in some member states, and there are also very recent plans of the European Commission that you may want to hear about early. With that said, let's begin without further delay. The duty of confidentiality. The duty of confidentiality is also often referred to as professional secrecy or legal professional privilege, even though those terms are, at least in their roots, not exactly identical. But for today's purposes, we will not be too fuzzy about it and just use it as synonyms. First of all, I want to highlight the importance of the duty of confidentiality. It may very well be the most important principle of our profession. As all over the world, IT service providers are designing tools trying to automate and sometimes rationalize legal services, the legal professional privilege may as well be one of the unique selling propositions of our profession. The site on your screen, taken from a recent decision, demonstrates clearly that the ECJ is sharing that point of view. The court acknowledges that professional secrecy is a fundamental right, but also a fundamental duty of lawyers. In the first place, the LPP, the legal professional privilege, is of course a right to the lawyer. The lawyer has the fundamental role to act as a safe haven for those who seek legal advice and have to share sensitive information in the course of it. He therefore must have the right that can be enforced to protect clients' interests. But on the other hand, the lawyer is obliged and has the duty to act in good faith towards his clients and towards his and her client. The client can reasonably expect that those communications will remain private and confidential. If the confidentiality of such information is not guaranteed, there can also not be trust. The protection of the duty of confidentiality is guaranteed on different levels. You may have found on my slide that there is mainly EU law, but please have mercy on me that I could not delve into the fundamental rights and laws of the different national systems of all CCBE and ELF members, but at least on the level of fundamental rights, and that is what I will focus on. Similar fundamental rights are usually provided also in other nationalities of Europe as well. The main fundamental rights protecting and safeguarding the duty of confidentiality are the protection of private life and family, home and communications in Article 8 of the ECHR and Article 7 of CFR, and the right of a fair trial in Article 6 ECHR and Article 47 and 48 of the CFR. The ECHR and the CFR afford protection to communication in general, but they do provide a special protection to the correspondence of independent lawyers with their clients. This is justified in particular by the fact that independent lawyers are assigned a fundamental role in democratic society, as the ECJ says. As regards legal defense before a court, that protection is especially guaranteed also by Article 47 and 48 of the Charter. But please keep in mind that the LPP is fundamentally protected in relation to any legal advice with regard to both its content and its existence, not only regarding the defense in criminal matters. As the ECJ recognizes lawyers not only as representatives of their clients' interests, but also as independent collaborators of the interests of justice. Therefore, lawyers also have part in fulfilling the requirements of the rule of law, and the LPP is also an expression of the principle of the rule of law on which the European Union is founded in accordance with Article 2 of the Treaty of the European Union. You will also see on your slide that secondary law and national law are mentioned. In secondary law, you will definitely find that the secondary law has to and therefore often reflects the core principle of the LPP. For example, it will foresee exceptions and restrictions in, for example, the anti-money laundering obligations. In depth, of course, you will find specific rules for the duty of confidentiality in basically every national law, in common law, mostly referred to as legal professional privilege, and in continental European law, mostly referred to as duty of confidentiality or professional secrecy. Now we come to the next slide where I show you a few relevant European case law that I am using also as a basis of information for my presentation here. I actually plan to give you at least some information to each of those rulings, but as a matter of time, I have to skip this and I will only inform you about a few important topics on this. First, it all began with the AM&S ruling of the ECJ in 1982, where the ECJ first recognized the importance of the confidentiality of the communication between the lawyer and the clients and upgraded the lawyer's duty of confidentiality and the legal professional privilege to a common principle in EU law. Then there was an interesting decision in 2010, the Akzo Nobel decision of the European Court of Justice, where it was clarified that only the communication between the client and external independent lawyers and not the communication between an in-house lawyer and its employer is protected by the legal professional privilege. Then there is also a few rulings mentioned where the ECJ, of course, acknowledges the right of the legal professional privilege and clarifies that it is protected as a fundamental principle of the EU, but it may also be limited by overriding reasons of public interest, so long as the core of the LPP is preserved. Restrictions on the LPP, as the ECJ says, are only possible in exceptional cases, and they must be clearly laid down by law, respect the essence of the right, and be necessary and proportionate in the light of the pursued legitimate objective. Then there is also one Austrian, it's an ECG ruling, but regarding a case in Austria, the Visa and Bicos Beteiligungen GmbH in 2003, where the ECJ, which is of course important for my part in IT law, clarified that the communication between the lawyer and the client is not only protected if it is stored on paper, but also, of course, if it is stored in electronic data. Then on to, or stepping into the data protection area a little closer, I want to outline the different areas of application real quick of the data protection and the duty of confidentiality. The data protection law is, as we all know, in general only designed for the protection of personal data, meaning any information relating to an identified or identifiable natural person. The duty of confidentiality protects in general communication between the lawyer and their clients, which basically includes all information that the lawyer obtains in the course of his professional activities or that comes to his knowledge in this capacity, including consultations with the lawyer, information disclosed to the lawyer prior to a consultation, facts that the lawyer learns from third parties, from his own observations or his own research, the documentation prepared by lawyers in the course of providing advice and representation. All those are protected by the legal professional privilege. The Court of First Instance of the European Union also clarified that the principle of the protection of written communication between lawyer and client must be extended also to internal notes of the lawyer. And even more interesting, it clarified that also preparatory documents of the client, even though they were not exchanged with the lawyer or were not even created for the purpose of being sent physically to the lawyer, are protected if provided, of course, that they were drawn up exclusively for the purpose of seeking legal advice from a lawyer. That is also said in the Akzo Nobel decision of the ECJ. On the other hand, the mere fact that a document has been discussed with a lawyer is not sufficient to give it protection by the legal professional privilege. Knowing all that, it is not difficult to see that the duty of confidentiality, at least in some areas, goes beyond data protection. I give you an example. Very recently, the ECJ ruled that the applicability of the GDPR is context dependent insofar as the nature of autonomization is not absolute, but depends on the perspective of the entity processing the data. If the entity does not have the means to identify the person, the data is considered anonymized, even though another entity may be able to identify the person. For the duty of confidentiality, the same may not be true. Even if you would completely anonymize a case file of your client, or specific documents do not even contain personal data, the lawyer would not be able to process the data in any way he wants. It may still be that the information contained in the privileged data has to be held confidential in the best interest of the client. Also, another more obvious example even would be that under the GDPR, only data of human data subjects are protected. The duty of confidentiality, of course, does also protect legal entity clients. That brings me right to the next topic. First of all, the next topic is, of course, cloud services and generative AI applications. First of all, I want to clarify the definitions. When I'm talking about cloud services or cloud computing, I'm referring mainly to the storing of data at an off-premise provider, meaning outside of the law firm and the lawyer's area of control. For example, the lawyer using Microsoft Azure or OneDrive or the German Hetzner solution or any other on the market. When I'm talking about Gen AI applications or Gen AI systems, I mean applications acting autonomously on a certain level and inferring from the input it receives how the data is, how to generate the output. Starting with the cloud services, I first, of course, as the chair of the IT Law Committee, have to highlight that there exists a guide by the CCBE called the CCBE Guidelines on the Use of Cloud Computing by bars and lawyers, which I would highly recommend. But other than that, I would want to come back to what I have said before and what the chart on your screen should demonstrate. If you're choosing to outsource the storage of client data in your law firm, you are not only deciding to assign a data processor in the means of Article 28 of the GDPR, you're also deciding to send privileged data to a third person. Though you not only have to comply with the data protection law, but also with the duty of confidentiality. And if you think such decisions are always made deliberately, I want to raise awareness that the trend on the market is definitely moving towards applications that include storage of data outside of your premise, and that it's not always the case that such storage is transparently highlighted by the providers of those applications. I may give you a few examples here for better understanding. Very recently, it has been observed by the French bar that the proposed new version of Microsoft Outlook will route and store email data on Microsoft servers also in the US and other third countries. This means that data of lawyers users, the login, the password on the mailbox, mail content, attachments, even address book and calendar information would be stored on the Microsoft Cloud. On this topic, the CCB is currently examining, of course, and will inform and intervene. Also, maybe some of you have used mobile scan applications like Adobe Scan on your phone. Those in most cases also send and store data to providers also outside of the EU and Europe. There was also a recent case in France of a Paris criminal lawyer using Google Drive for the storage of his client's data in a criminal case. He saved 77 child pornography images, legally saved them or legally possessed them because it was part of the case he was working on. And Google detected, the Google algorithm must have detected those images and terminated the account, making it unable for the lawyer to access his client's data. And of course, that does not mean that each and every application that stores data outside of the lawyer's premise is prohibited. But of course, lawyers, and that is what I want to highlight, have to check on their national professional rules thoroughly if such outsourcing measures are legal, especially if they are in the client's best interest. For example, in Austria, I would have to make sure that the interests of the clients are safeguarded, the external service provider is selected carefully, it is obliged contractually with verifiable documentation to inform me without any delay in the event of a search of premises. The state of art, the technical and organizational measures are met, of course, and the data security. And I have to inform the client about the categories of external service providers engaged and the services provided by them. Now, coming to GenAI applications, first of all, I want to highlight that there, of course, will be also a CCBE guide called the CCBE Guidelines on the Use of Generative AI by lawyers, at least if it is approved at the Standing Committee and on the 2nd of October. For GenAI applications, I want to mention that basically the same principles apply as to the cloud computing services, because in most cases, the AI system will be operated outside of the law firm and the lawyer's area of control. It is only that we have to be even more careful because when choosing the AI system provider, because it is not always clear what hides behind the tempting input line that you see when you're using, for example, ChatGPT. This is what I also wanted to show on my slide that you can see on your screen, that we have to differentiate between the AI system provider and the AI model provider. Popular and large options on the market like OpenAI, ChatGPT, Google Gemini, and so on, they use their own model and they typically operate on servers all around the world. Then there is smaller providers also in Europe, like for lawyers Lexis Plus AI and other providers on the market that do sometimes also use models like GPT-4, which will in most cases still operate at OpenAI in the US. Then there are also smaller, sometimes less powerful options which use OpenAI models that can then be operated exclusively on servers of the AI service system provider, who is then enabled to operate the system exclusively on European servers. Please bear in mind that data that is entered into the user interface of the GenAI application may be stored and reused by the provider for purposes of training, refining, and improving the AI model, unless it is stipulated otherwise. Many AI model providers will save the prompts inserted by the user. Not all of them provide options for zero data retention. With that all said, I want to highlight that it is very important to screen the providers and their contractual policies so that we are able to elaborate if the outsourcing complies with our professional obligations. I will now continue with the right to access and the duty of confidentiality.
Just quickly to say, just a couple of minutes, sorry, Dominic, this is
Yes.
highly interesting. Please, thank you.
Okay, thank you. In the course of legal practice, personal data relating to both the lawyer's own client and the third parties, such as the opposing party, is naturally processed. It is therefore necessary to examine the extent on which those parties' right to access under data protection law must be complied with, despite the lawyer's duty of confidentiality. As a general principle, as we all know, the right of access is guaranteed widely and unlimited by Article 15 of the GDPR. On another place, though, specifically in Article 23, the GDPR respects conflicting rights and foresees necessary and proportionate restrictions by union and member state law, respecting the essence of the fundamental rights and freedoms. One of those rights is the duty of confidentiality. It is therefore possible and necessary that the member states foresee restrictions of the data subject rights when they are conflicting with the legal professional privilege. In Austria, for example, that was done in Article 9 of the Austrian Lawyers Act. In this regard, the right to access of the client, him or herself, is disregarded. Let me restart. In this regard, we will disregard the right of access of the client himself, because as a rule, there is typically no conflict with the attorney's duty of confidentiality in that case. We will therefore focus on the right to access of third parties, especially the opposing party. And here the question is raised as to if and which information must be disclosed within the meaning of the GDPR and which information can be disclosed without risk. I want to refer at this point to a ruling of the Austrian Administrative Court. The Austrian Administrative Court says that a blanket reference to the attorney-client privilege as a response to a request for information is, in general, inadmissible. It says it is always a matter of the specific case. The Administrative Court did clearly state, though, that a lawyer cannot be compelled on the basis of the right to access under data protection law to disclose information about the content of documents provided by his client or about the content of email correspondence with the client that is subject to professional secrecy, even if such document contain computer processed data relating to a person requesting information. In my personal opinion, requesting a copy of those documents is in most times not covered by Article 15 of the GDPR and would violate attorney-client privilege. In terms of content, the lawyer may often be able to limit himself to providing information on the categories of personal data and other mandatory catalog information. Jonathan,
Yes,
I see
Dominic.
you're on the screen again.
Yes. I'm sorry to do that because really, really so interesting. The examples you gave were fascinating. Thank you so much. We must move on, otherwise we will not keep up with our time. Dominic, as you can see, has produced slides to answer some of the questions. We don't send the slides out, but they will be put on our website by the end of the day. You can get all the information, all the references there. Thank you, Dominic. Also, quickly before we move on, I see people are sending us their bar registration numbers. To repeat what I said at the outset, we do not issue certificates. Your bar will recognize your training. I think I said wrongly before, the bar will issue certificates. The bar will recognize your training. They will apply to us to see if you connected, but we do not do anything other than communicate with your bars. So approach your bars. Thank you very much, Dominic. Sorry to move on. Our next speaker, whom I'm very pleased to welcome, is Karolina Mojzesovic, and I hope I pronounced that correctly, from the European Commission. Karolina is going to speak to us about the latest developments in data protection and give a general introduction. She's Deputy Head of the Unit for Data Protection at DG Justice and Consumers at the European Commission. She's responsible there for data protection and represented the Commission in all the negotiations with Parliament and Council on the GDPR, and she's now continues to be responsible for ongoing policy. And she's before that she was with the European Commission's legal service, and she represented the Commission in many cases before the European courts and the WTO. Karolina, we're very pleased to see you, and welcome.
Jonathan, thank you very much for such a warm welcoming. It's a pleasure and honor to be here in front of such a forum. I was asked to give you today a very general presentation about concerning the latest developments on broadly understood personal data. So it will be more a sketch out of the policy developments, and I think there I will cater a little bit more into all the stories about, do we reopen GDPR, should it be reopened, what is also going on with the plethora of all the remaining legislation in the European Union in the digital sphere, in particular, the acts as Digital Services Act, Digital Markets Act, Data Act, and so on. But I think that I will be not as concrete as Dr. Gerstberger was just before, because, as I said, I was asked to give a general, more policy-related presentation. So is my understanding correct, Jonathan, that you will be presenting the slides, or I should
Right. No, I mean, we have your slide. So if you would prefer it, then Vasilis, who's in the background, can present your slides, but then you must say next slide when you want to move
Perfect.
on.
Of course. I
Vasilis,
think it will be, I think it
perfect.
will be better.
And
Yeah.
you're right, we want the policy from you. You're
Yeah,
absolutely right.
exactly.
So
So because I
Vasilis,
was
if you...
looking at the presentation before that and I thought, whoa,
No,
it's a
it's
little
only
bit
because
different. My story is going
it's
to be
only
much
because
more
we've
general.
swapped them round. Otherwise, you would have
Yes.
given the general policy and
Yes.
he would have given the detail. No problem. And
Of
your
course.
slides are just coming up. Vasilis, you need to make them full screen.
Perfect.
So you
Thank you
carry
very
on,
much.
please, Carolina.
Okay. So the GDPR is applicable already since the 25th of May 2018, and we have all seen diverging developments. We have seen developments concerning, the speed, the take-up of the digital solutions. We have seen work of data protection authorities and the European Data Protection Board trying to, or not trying, on data protection authorities implementing or enforcing the GDPR through national cases, and on the forum of European Data Protection Board, the data protection authorities altogether giving an interpretation of the and the guidelines of the rules contained in the GDPR. On the basis of the GDPR, we, the Commission, we have an obligation to issue a communication summing up the results of the application of the GDPR. We issued such a communication in 2020, and we just in July 2024 issued another the latest communication. What did we find there? First of all, that although the GDPR provides for variety of consistency tools and for the famous one-stop shop, there is still of this one regulation, while in law, a diverging interpretation on key data protection concepts. And here I'm thinking about the concept of controller, processor, and concept of personal data. Throughout the European Union, unfortunately, in the communication 2024, we found the fragmentation in the way data protection authorities are enforcing the law. Secondly, as you know, GDPR is based on a risk. What does it mean? As you will know, but allow me to just recall shortly, the degree of the safeguards and the obligations which the controller needs to meet depends on the risk the processing of personal data would means to the data subject. So the more risky the processing, the more the gravest the possible infringements in the rights of data subjects should something go wrong, the biggest obligations on the controller. Now, we found that the way data protection authorities and the European Data Protection Board were interpreting the law was not really in line with this risk-based approach. A lot of stakeholders which took part in the evidence gathering exercise which we undertook before writing the communication were raising points such as over legislation or over interpretation of some notions in the GDPR through the data protection authorities, while enforcing in individual decisions the GDPR, and secondly, while providing for guidances in more general guidelines, such as the guidelines on risks, anonymization, and so many other topics the European Data Protection Board is adopting. Thirdly, in the communication, we found, or we stated, that the guidelines, which are supposed to be a support, in particular for small and medium-sized enterprises, are just too long and too complex. And sometimes, so apart of not necessarily, not always matching the risk-based approach, the mere language of the guidelines is not such as to be of help, in particular to small and medium-sized undertakings. And the undertakings were also raising with the Commission the problems of a lack of clear templates and models and interactive pages which would allow them, for example, to notify a data breach or similar. Finally, and here I will be moving to the next slide, we found that, and this was already mentioned in the previous communications, that a lot of problems concerning enforcement in individual decisions, but cross-border, so problems with the speed of the enforcement in big cross-border cases in the European Union, went back to the lack of harmonization of procedural rules the data protection authorities need to apply. So, just to be clear, when an authority A, which in a specific cross-border case would be a leader, was applying its national administrative procedural rules, they do not necessarily match with those of the authorities concerned, of the authority in particular, of where the complaint, should there have been a complaint, was lodged. Therefore, very quickly, we acted in order to support the authorities so that they would be able to quicker enforce the GDPR in cross-border cases, which are addressing, in particular, big processing of data by big platforms, where this processing affects all the residents of the European Union. So in July 2023, we adopted a proposal for the General Data Protection Procedural Regulation, which is complementing that of the General Data Protection Regulation. Let me underline that this procedural regulation does not change any obligations of the controllers or rights of data subjects. This procedural regulation provides for detailed rules just to support the smooth functioning of the cooperation and consistency mechanism, so the one-stop shop. The aim of this regulation is to harmonize procedural rules to be followed by data protection authorities while cooperating in cross-border cases, be it based on a complaint, be it cases started ex officio / own volition inquiries. And the aim, therefore, of this procedural regulation is to provide for clarity and legal certainty. What is there exactly? So the political agreement on this, maybe before I will move to the content a little bit more, the political agreement was reached before the summer. The political agreement between the Council and the European Parliament. So, and now the so-called legal revisers are going through their last version of the text in order to enable the translation services of the institutions to translate the text to be adopted on time and truthfully and correspondingly with the a national vocabulary concerning procedural law, and the final text should be adopted very soon, still in the autumn. We hope very much for November. What does this procedural regulation clarify? Very shortly, for the businesses, for the controllers. So for the company who has the main establishment on the territory, on the area of competence of the lead authority. For this controller, for this business, it means that the way we set up the rules, their due process rights will be observed when the data protection authority investigates such a potential breach of the GDPR. They will be observed in a more harmonized way. So the procedural regulation fixes exactly the moments in the procedure when the controller, which is investigated, so-called party under investigation in the text of the procedural regulation. So when this party under investigation can respond to the allegations. To be very brief, the party under investigation will be able to get access to the file and pronounce himself on all allegation. The investigating authority, the lead authority, set up together with concerned authorities, and which will be embodied in a document called preliminary findings. So this document will include all the allegations, legal analysis, the consequences of the breach. Should there be a fine? Should there be a remedy? And at this point in time, the controller will be given access to the administrative file, which will contain all the inculpatory and exculpatory evidence. We clarify also the rules applicable to the or the rules shaping procedural rights of the complainants, because there, in particular, throughout the European Union, the complainants have very different positions. What depends also on the on which administrative investigation process the authorities follow. And here we distinguish between two, more prosecutorial and more adversarial, and in particular in these two different these processes, the position of the complainant was very different, in particular when the complaint was followed up by the authority, so not when the complaint was rejected, and therefore a rule or a measure which would be adversely affecting the complainant was contemplated. So just to sum up, the procedural regulation clarifies what information individuals need to submit when making a complaint. So here this element of the harmonization of what is a complaint, what can be expected from an individual in order to lodge something that will be accepted across the board in the whole European Union as a complaint. There were also differences. And therefore, we will be removing this procedural regulation removes the obstacles brought by the data protection authorities following different rules. So something that was assessed as a valid complaint in one member state was still not sufficiently substantiated or didn't meet some requirements for another member state, what of course in cross-border cases caused a lot of problems. And on this I was already talking quite a lot, this procedural regulation harmonizes the due process rights under parties under investigation, including the right to be heard before the data protection authorities and the European Data Protection Board, should there be a procedure under Article 65 GDPR, and access to the file. The procedural regulation ensures that complainants are appropriately involved in the process. For example, the complainants will have a right to express their views on how data protection authority intends to deal with their case. Also, here I would like to underline it, when a data protection authority does not reject the complaint but follows up on the complaint. So also in this situation, a complainant will have a right to express its views. We provide, a procedural regulation provides even for access to non-confidential version of preliminary findings. So when the case is already so far developed that allegations are presented to the parties under investigation, to this document, the complainant will also have access, the non-confidential version of it. Furthermore, we provide for very concrete rules on cooperation between the DPAs because unfortunately the cross-border cases took and are still taking a very long time. We still have very big cases against very big controllers, which were started in 2018 and are not finalized. So there was a problem, and we had quite a lot of dispute resolution cases on the level of the European Data Protection Board, which takes additional time, so that the procedural regulation provides for very clear rules about how the data protection authorities need to cooperate in order to reach a consensus about, in the sense of Article 60 of the GDPR, about how the case should be resolved as soon as possible, how they should share information, what is the right time to share information, and indeed how to resolve their disagreements upfront. The procedural regulation finally provides for fixed deadlines for data protection authorities, so as to ensure that the investigation progresses and we are not in a situation of an investigation taking over 6 or more years. Another very important point, which was raised already in the communication 2024, is, if we can move to the next file, the so-called cross-regulatory cooperation. And this cross-regulatory cooperation is in particular important when we are looking at all the new enacted since 2018 legislation which complements or specifies how the GDPR applies in specific areas. So, and I think I would like you to retain from the small introduction 2 messages here. The acts which you see here, and there's still not all of them, because we still have the Data Act and European Health Data Space and so on, they do not as such regulate processing of personal data. Or better said, the aim is not to regulate processing of personal data in the way the GDPR does it. So in this horizontal way concerning private and public sector, providing the tools for processing of personal data, and so on. So this is not this. This legislation specifically addresses certain failures or shapes, maybe some addresses failures and some shape interaction in a digital sphere as far as specific situations are concerned. But since in the digital sphere personal data is being processed, these regulations touch upon, so complement, specify the GDPR. For example, the Digital Services Act addresses intermediaries in the internet. Its aim is to provide for safe online environment. It does not regulate the processing of personal data as such, but provides, for example, in Article 26 and 28 of the Act, for restriction of possibility for very large online platforms to process to engage in personalized advertisement in certain circumstances. And here it's the reduction of the possibility of providing personalized advertisement on the basis of minors data or on the basis of the sensitive data. Yeah, so here we have a reduction. Digital Markets Act. Digital Markets Act is more a common market / competition tool which addresses or which aims at achieving contestable, fair and contestable digital markets. It's addressed to so-called gatekeepers. Who are gatekeepers is designated on the basis of, by the Commission on the basis of criteria provided in that regulation. And the Data Markets Act does not regulate processing as such, but by providing for do's and don'ts, obligations for the and prohibitions to the gatekeepers, it touches upon notions or concepts or solutions from the GDPR. And here the most important one, and this will be mentioned also a little bit later, is the so-called pay and okay. So the possibility of the gatekeepers to combine or cross-use personal data in order to offer personalized advertisement. Here you have maybe heard about the decision the Commission adopted in April this year, addressed to Meta on the basis of Article 5.2 from the DMA, precisely addressing these conditions of pay and okay and how how Meta complies or does not comply with the obligations under this prohibition under Article 5.2. The same for AI Act directive, because I see I have to finish and we will need to move to another slide very quickly. But just to underline, so that we have this cross-regulatory cooperation and that in these areas we have a consistent interpretation between different enforcers, because Digital Services Act, there are enforcers on the national level, and as far as very large online platforms and search engines are concerned, it's the Commission. Digital Markets Act, the Commission. AI Act, it's also division between national authorities and the Commission, and so on, so that this cooperation works well. And in particular, there is consistent interpretation as far as data protection notions are concerned in this act. There's a lot of work on guidelines which already were or are to be adopted by the European Data Protection Board and the Commission. As far as the I see I missed the word act in the Digital Services Act. So as far as the DSA is concerned, the guidelines were already adopted. For the Digital Markets Act, the guidelines are to be adopted. The guidelines on DMA and GDPR, DSA and GDPR. On AI Act, the AI Office and the European Data Protection Board work together. So, but this question of this cross-border cross-regulatory cooperation is very important. Everybody is very much aware of it. This needs to work so that it's consistent and possibly simple to the businesses. Let me move to the last slide, and I will be closing here. So in the light of all of that, what is happening? Do we reopen? Don't we reopen? What is going on? There is a lot of fuss about is there a need to reopen and to reshape the GDPR? So in order to, and this in particular in the light of the Draghi report and the competitiveness compass adopted by the Commission in the beginning of this year, Draghi report indicated that there is a need to ensure that this EU digital rule book for businesses needs to be consistent, coherent. Therefore, this cross-regulatory cooperation. Draghi complained very much about still fragmentation, which we found already in the communication. He reinforced that there needs to be more action towards making the union more prosperous, competitive, resilient. Therefore, less fragmentation, more simplification, and so on. In order to find it out what exactly businesses need in order to be more competitive and how much is this, what does mean the burden of the GDPR, we engaged in the implementation dialogue, which took place on the 16th of July, which was chaired by the Commissioner McGrath. It was an opportunity to hear firsthand from the businesses, and shortly afterwards, the member states met during the JHA, so Justice and Home Affairs Council in Copenhagen, just in July this year. And the main message was that both member states and the stakeholders, European stakeholders, SMEs, are not in favor of general reopening of the GDPR. They consider that the GDPR is a legal framework that has met its objective, takes into account different interests in a balanced way. For businesses now, looking at all this plethora of new legislation and so on, they want stability, but everybody underlined need for some targeted measures, including possible targeted surgical amendments to the GDPR to enhance clarity, simplify obligations, in order to not to have this fragmentation, and also in order to have a truly risk-based enforcement, notably as far as AI and new technologies are concerned. So these are the results of the implementation dialogue, which were made on the basis of the oral submissions and also the documents which the Commission received. These are all public documents, and they are accessible already now. The last, sorry, Jonathan, the last slides, the already targeted amendment in which we engaged is that, as you know, in Article 30.5 GDPR, only SMEs and organizations with less than 250 employees are accepted from record-keeping obligations. This new proposal, which just went through the Council and the interinstitutional negotiation will start on it, simplifies this record keeping for small and medium-sized companies, enlarging it to small mid-cap companies and organizations with less than 700 employees. All those, so small mid-cap companies and organizations with less than 750 employees will not have to comply with the obligation under Article 30.5 if they do not if they comply still with additional condition which concerns mainly the sensitiveness of the data. And I think that this plea for legal clarity, a lot of was said during the implementation dialogue about the need to clarify the notion of personal data. You have seen what is going on with the pseudonymization guidelines. There was a public consultation on that. I saw it mentioned already before. And I think I cannot finish this small introduction without mentioning the case C413, the very, very last slide, C413/23, pouvoir, so appeal, SRB case, where the court clarified what does it mean pseudonymous data. And this is a very important clarification, which actually the businesses and controllers wanted to get already when they were speaking to us in July. So the question is it still needed to provide further clarification? The act is the fact that the Court of Justice already provided for it in a judgment sufficient. And without further ado, I will stop here because I know that there
No,
are
no, thank you. That was fascinating, Carolina. And particularly at the end, that was all very, very interesting. And the pay, I always wonder about, I didn't realize the Commission had already answered on the pay or watch. So that's very interesting. But we mustn't stop.
This is a very, it's the reason I was dwelling so long on this cross-regulatory cooperation, because now the very same conduct will be addressed by different regulators from different angles. Here, it's a gatekeeper, right? So the gatekeeper is directly regulated by the Commission through the DMA Act and this Article 5.2, therefore pay and okay. But we have also an investigation by the Irish Data Protection Authority concerning the very same conduct, and by the European consumer authorities. So the CPC is also engaged in a coordinated action and addresses Meta on the very same issue, always from a different angle. It's the reason the cross-regulatory cooperation will become more and more important.
Thank you, thank you. We must move on. Thank you so much indeed.
Thank you very much for having me.
No, great pleasure, great pleasure. We move on now to our next session, which is on the interplay between the GDPR and the EU AI Act, which you touched on, but we'll now go on to in more detail. Our speaker is Peter Homaki, a lawyer from the Hungarian Bar Association, a former chair and a current member of the CCBE's IT Law Committee, and author of the Guide on the Use of Artificial Intelligence-Based Tools by Lawyers and Law Firms in the EU, published by the CCBE and the Foundation. Peter, over to you, please.
Thank you, Jonathan. Thank you. I hope you can hear me, see the slides.
Hear and see. Thank you.
Thank you. So thank you for the introduction and for being able to present on this topic after this very interesting presentation we have heard about which partly affected this area as well. So I will talk about the GDPR and the EU AI Act, the interaction between the two. So first, I would like to give an overview of why privacy is at the forefront of regulating the risks of AI. Then I will show you some similarities and differences between the two regimes, how differently they regulate the issue of automated decision-making and profiling in more details. Then I will try to discuss two related cases. One actually is the Glukin versus Russia case from 2023, which was decided at the European Court of Human Rights. And the other is, well, it's not really a case law yet. It's more like a practical event where the legal consequences are still unfolding. You know, what happened in relation to automated facial recognition at the Budapest Pride in 2025, and why the regulatory approach of the EU is not really in line with the approach of the European Convention on Human Rights and the decision in Glukin. In the EU, the regulation of artificial intelligence became one of the most important tools in the mitigation of risk caused by the AI systems. And privacy was one of the foremost risks mentioned in the preparative works and materials for the AI Act. The risk of privacy is not really a distant, remote risk like the existential fears for AI conquering humanity or the fears of displacement of our jobs. Also, among the many risks of society using AI, risk related to data privacy is an area where the EU already has shared competence with its member states. Like Article 16 of the Treaty on the Functioning of the European Union, privacy is also a fundamental right, and it's protected not only by just the Charter of Fundamental Rights of the EU, but also by Article 8 of the European Convention on Human Rights. This also means that the protection of the Convention extends beyond the scope of the EU law, such as in the areas like national security or military, unlike the EU AI Act again. In theory, the GDPR was already capable of addressing many risks related to the use of AI, but the EU bodies wanted yet another horizontal regulation to be put in place. What were the reasons? To say that AI systems might have some specific features such as opacity, of the tools or the complexity of the technology that could make the enforcement of the existing legislation like GDPR more difficult. Also, some AI practices are deemed to be so dangerous from a privacy point of view that lawmakers decided clear, outright bans that were needed for private entities under a separate regulation and not under GDPR. However, at the same time, the AI Act allows the same practices for law enforcement purposes within a set of quite flexible frameworks. The third reason was that the best way to preempt further fragmentation of the AI market is to adopt a new horizontal regulation for AI products with all the technical details of compliance outsourced to standardization bodies who will work out these details, hopefully by the end of 2026. So let's go to the similarities. The legal basis for both regulations is to protect fundamental rights. GDPR is focused on the right to privacy and data protection and how this right is to be protected in practice. For the AI Act, the focus is a lot wider because it tries to address the negative possible effects of AI systems on many other fundamental rights, like freedom of assembly, workers' rights, IP rights, children's rights. But the EU does not have general competence to harmonize fundamental rights. So that's the reason why the legal basis for the EU AI Act is also the functioning of the internal market, Article 114 of the treaty on the functioning of the EU. Another similarity is that both regulations are very wide in scope, and they affect our everyday digital life, so hardly a day of an EU citizen can pass without being subjected to either or one or two of these, both of these regulations. Both regulations declare that they rely on a kind of risk-based approach. Because the reason was that the lawmakers said they strive to achieve a proportionate balance between reducing the risk posed by the activity and the costs of regulation. For the GDPR, this aspect is mostly visible when we take a look at the practice of the supervisory authorities, how they have some flexibility in applying certain legal terms of the regulation, like what is personal data or anonymization, as we have seen, what is processing. But for the AI Act, this flexibility is currently present only at a very high level of the regulation. The risk-based approach is the main reason why we have like 4 different categories of AI. We will talk about this one a bit later. So both regulations rely on a regulative principle called technological neutrality, and therefore they both try to solve important questions by postponing regulation of certain issues we expect will happen, or by delegating the actual regulation to third parties. In relation to the first area, the lawmaker is hopeful that some other details can be left to those being regulated, which is a form of self-regulation, like the principles of something by design, such as data protection by design and by default in Article 25 of the GDPR, or the transparency, accuracy, and human oversight requirements in the design phase of the AI Act, where it's not expressly said that this is an accuracy by design or human oversight by design, but in practice, the provisions arise from the same regulatory principle. Subsidiarity is similar to delegation in this regard. Important questions will have to be solved by the member states, by the courts, by national practices and national authorities. As we have seen with the GDPR, this results in considerable divergence, and we can expect the same to happen with the AI Act as well. In order to address some of these divergences, both regulations have in place some EU-level coordination added at the top, like the European Data Protection Board and the European AI Board. Both regulations have extraterritorial reach. The processing of personal data of data subjects in the EU triggers the GDPR regardless of where the data controller or processor is based. Similarly, all the AI Act rules apply to deployers and providers established outside the EU, as long as they make the artificial intelligence system available for use in the EU. And of course, both regulations rely on heavy fines to ensure compliance, like the 20 million euro maximum fine with an upper limit of 4% global turnover for the GDPR, and the even higher one for the AI Act in relation to prohibited practices, like 35 million euros and 7%. What are the most prominent differences between these two regulations? Of course, the focus of the GDPR is when personal data is processed. why the focus of the AI Act is more diverse, because it has at least 4 different regulatory purposes, depending on what category the AI system belongs to. Is an AI system used in the market or put into circulation? Is that a high-risk AI system? Is it general-purpose AI system? Even a general-purpose AI system with systemic risk, they all have different regulatory consequences. The GDPR is about unpacking the protection of a single fundamental right into more detailed principles with considerable number of practically exercisable rights to ensure compliance. Whereas the EU AI Act is more about product regulation, differentiated in accordance with the 4 risk categories mentioned above. The provisions in the GDPR mostly follow an approach that is called ex post approach. It defines the rules and entrusts supervisory authorities to enforce compliance with these rules. Whereas the AI Act is more about ex ante regulation. How should the system be designed in a way that complies with these requirements? What should be done by the deployers and the providers before putting the AI system into circulation? Furthermore, the GDPR itself relies on the use of codes of conduct in only a very minimalistic way in Article 40. It's more like a precautionary step that certain bodies can decide to take to enhance their compliance, to increase the legal certainty about compliance. On the other hand, for the AI Act, while the codes of conduct in Article 95 seem to be voluntary, and in practice, they are expected to fill out important missing parts of the regulation. These codes of conduct are more similar to the codes of practice in the AI Act in Article 56, a tool for self-regulation in the AI Act with the threat of the Commission stepping in to provide common rules. The GDPR contains lots of detailed rules about how the data subjects can enforce their rights, whereas the EU AI Act does not really focus on the rights of affected persons beyond the rather limited rights under Article 85-86, like the right to lodge a complaint or expect the explanation of an individual decision-making from the deployer of an AI system. Let's talk a bit about the regulation of the automated decision-making and profiling in the GDPR and the Law Enforcement Directive. The most important rules on automated decision-making are about decisions that are based on solely automated processing, which has a legal effect concerning the data subject. In terms of the Law Enforcement Directive, this use is possible only if it is authorized by law, with appropriate safeguards, such as the possibility of human intervention. It is prohibited if it's based on special categories of personal data or results in discrimination against natural persons. While the GDPR also covers some further exceptions, it is also allowed if the solely automated processing is necessary to perform a contract or if the data subject has given his or her explicit consent. In terms of safeguards, in the GDPR can also find the right of the data subject to express their views and their right to contest the decision. In addition to these provisions, the GDPR also mentions the right of the data subject to receive information on the existence of any automated decision-making. So this is not only covering those based on solely on automated processing, this also includes cases where the human makes the decision in the end, but the decision relies on the results of some automated processing. In contrast with the GDPR and the Law Enforcement Directive rules, the AI Act has more piecemeal rules. But the AI Act is relying on the definition of profiling as used in the GDPR. So the AI Act itself has 3 different provisions which relate to automated decision-making. One is about the prohibition of risk assessment systems to evaluate the chances of natural persons committing criminal offenses, but there is no such prohibition in place as long as the AI system is just used to support human assessment of the same. The second use is the generic exemption from being considered as high-risk AI will not apply if the AI system is doing some kind of profiling work. Most importantly, there is a right to explanation, which applies to any kind of automated decision based on the output from a high-risk AI system. This applies even if the AI system was used only to support human assessment. We can see that most of the prohibited practices of the AI Act in Article 5 have some kind of privacy-related aspects, like social scoring, criminal risk assessment, untargeted scraping, of facial images for facial recognition, or the inferring the emotions of natural persons in the workplace. We will discuss the last issue a bit more, the issue of real-time biometric identification. Let's see the first example from Russia and the European Court of Human Rights. Nikolai Glukin was traveling on the subway with a cardboard figure of another Russian activist and a peaceful protest sign, and posted this on his Telegram channel. He was fined for not notifying the Russian authorities of his demonstration, because such notification is required for quickly assembled objects used in demonstrations. Glukin was identified using videos of closed-circuit cameras based on the evidence recorded on camera and fined. The European Court of Human Rights decided that there was a breach of Article 8 as well as Article 10, but we will not go into the details about the latter. During this presentation, the court said that though interference had legal basis in domestic law, the local law was not appropriate because it did not contain limitations on the nature of situations which might give rise to the use of facial recognition, or on the intended purposes of facial recognition allowed, or on the categories of people who might be targeted, or the processing of sensitive personal data, and it also lacked procedural safeguards accompanying the use of facial recognition, like authorization procedures. The court said that it was essential in the context of implementing facial recognition technology to have detailed rules governing the scope and application of measures, as well as strong safeguards against the risk of abuse. Now, the court also found that the measures taken against the applicant were intrusive because they have used live facial recognition technology. Also, the personal data processed was sensitive because they contained information about the applicant's political opinion. The court also highlighted that the applicant had been prosecuted for a minor administrative offense on the basis of facial recognition technologies. This activity itself did not otherwise represent any danger to public order. As part of this, the court also highlighted that this use of the facial recognition could have a chilling effect in relation to the rights to freedom of expression and assembly. So a short summary, 4 items in the decision. There were, we will return to this one a bit later, but no limitation on facial recognition use in the legislation, live facial recognition use, and the CCTV image contained sensitive data due to the participation in a protest, and the facial recognition was used for a minor offense. In relation to the Budapest Pride, let's start with what happened on the 15th of April. The Hungarian parliament has adopted the 15th amendment of the base law, which was originally adopted in 2011, and also a new act which partly extended the act on the right of assembly with some new prohibitions, as well as amended the act on petty offenses with a specific new offense, and also amended the act on facial analysis register. The amendment of the act on petty offenses now allowed the use of facial recognition systems to establish the identity of a person suspected of committing an offense as regulated in detail on the act on facial recognition, facial register. The act on facial analysis register included a legal basis for using the registry for law enforcement purposes, but before 2024, it was only allowed to prevent, detect, and interrupt crimes. However, after 2024, the same facial recognition could be used also for a more stricter category of petty offenses, those kinds that are punishable by detention, because that's different from country to country, but in Hungary, there is a very important difference between crimes and petty offenses, even if some petty offenses can be punished by detention. Some other laws, like in English law, you don't have this differentiation necessary. It is very important in this case. And so the latest amendment in 2025, this scope was made even wider, so that committing any kind of petty offenses could be a legal basis to use the facial recognition. A new provision was also included in the Act that enables the use of facial recognition for mass identification purposes as well. We also have to highlight that the Facial Recognition Act already included procedural safeguards, like only a central body was allowed to do this kind of recognition, and it had to delete all the data after 30 days of the identification. The next slide is not really about data privacy, but it's important to understand the privacy aspects as well. So based on the changes in the base law and the Act on Assembly, the police prohibited several notifications sent regarding planned assemblies of Pride in June. Thanks to the April changes, the Act on Assembly now included an express prohibition on holding assemblies that present the essential elements of A, promoting deviation from gender identity corresponding to birth sex, or B, promoting homosexuality. Each such prohibition by the police was appealed, and each appeal was decided directly by the Supreme Court. In several very quick decisions, the Supreme Court actually led the hand of the police on how to formulate the prohibition in a way that the Supreme Court will approve the prohibitions next time. So after several rounds of restarting the administrative procedure, the Supreme Court finally gave its approval to the prohibition issued by the police. This way, everything fell in place. There was a planned Pride assembly, there was a prohibition in place, and there was a provision that anybody attending a prohibited assembly can be identified by the use of facial recognition technology. Despite the prohibition, the Budapest Pride 2025 took place with many, many attendees. So far, there is no news about anyone having been subjected to fines for attending the banned assembly. But there was a question submitted by one of the members of the parliaments to the ministry asking about whether the police is using automated facial recognition to issue fines. To this exact question, the answer was no, and the reasoning given was that they don't see it legally possible to fully automate the decision-making in an offense-based administrative procedure, because human supervision is a necessary part of an offense-based administrative process. So beyond this reassuring answer, of course, it doesn't mean that there will be no offense proceedings or none are taking place. But even if there are such processes in place, due to the procedural safeguards, the Facial Recognition Act, it will take a long time. And it will probably take many, many years if they wanted to identify everyone who attended. Now, let's compare the differences between this case and the Gluckin case. Compared to Gluckin, the first condition on not having limitations on the use of facial recognition is not true, not fully. We see there are strong safeguards present in the Facial Recognition Act. It requires the retention of recourse used, and the affected person also have the right to access. Secondly, this is not really live facial recognition. Even if there will be any use of facial recognition, that will take place long after the banned assembly, even compared to Gluckin. Because in Gluckin, there were like 6 days passed between the recognition and the administrative acts, and still the court considered this as a live facial recognition event. And the third condition is fulfilled even in the Budapest Pride case, because the closed-circuit images will reveal participants' political opinion, or even, depending on the behavior, sexual opinion, orientation as well. So the data is definitely sensitive data, even if used only for identification. And the fourth condition is also fulfilled because facial recognition is used for a minor administrative offense, which otherwise presents no danger to public order, and more importantly, the possibility to use facial recognition to identify anyone committing even a petty offense was included on purpose to have a chilling effect to discourage people from attending the prohibited assembly. As you can see, Article 5, Paragraph 1, the prohibition of the AI Act in this area does not really apply to this activity, because the use of facial recognition cameras was not real-time use. The wider problem is whether this prohibition will apply to very, very limited cases at all, like when a police is in hot pursuit of dangerous criminals, or where imminent actions are needed to find a victim or prevent a terrorist attack. Just a delay of 5 to 10 minutes could be used as an excuse for biometric identification not being considered real-time. The EU Act Preamble 17 equates real-time systems with live or near-live recognition. And it seems that even the use of the facial recognition in the Gluckin case would not be considered as a real-time use of biometric identification under the AI Act. So technically, locating a protester in the metro 6 days after the protest is not really live facial recognition in this regard. But still, the European Court of Human Rights came to a different conclusion in this regard, and how they defined live use of facial recognition they just mentioned without any direct evidence that the absence of any other explanation for the rapid identification and the implicit acknowledgement by the government that they use live facial recognition. So most uses of the facial recognition by the police will not be prohibited activity, but they will need to follow stricter rules in the design and operation of the AI system, because they will be considered high-risk AI systems. And even these provisions of high-risk AI systems will only apply from August 2026. So law enforcement will have like a different approach to how we would otherwise approach this question of AI systems facial recognition as based on the European Court of Human Rights discussions. That would be the presentation. Thank you. Thank you very much.
Peter, thank you so much. First of all, for your excellent presentation. Secondly, for keeping to the time so wonderfully. I'm very grateful indeed. And I'm going to take advantage of that to ask, in fact, some questions have come in. I'm sorry for Daiva Tamulun, I can't pronounce the surname, about the question for our EC representative because she left. I did try to bring it to her attention. But Albert Fabian has asked a question which I'd quickly like to get through. It's actually for Dominic, who says that there's so many AI legal tech providers, AI models, it's difficult to navigate among them and to verify their policies. Is CCBE considering introducing a certification for legal tech AI providers proving their system complying with CCBE recommendations and respect professional secrecy, which could obviously help lawyers? I know you know the answer to this as well, Peter, but let's ask Dominic, and be very brief, Dominic.
Yes, thank you very much for the question. The ideas of introducing a certification as CCBE or even providing an AI application database has been brought up in the IT Law Committee as well. But it is not yet considered for more than one reason. One reason would be that the CCBE has refrained from marketing for any market provider, of course. Also, it is a topic of resources, because we will, at the time, we would not be able to administer a database or even a certification authorization. Yes, we are considering, but will not do, most likely, at least at the time. But there will be more guidance, even more guidance than the guide that is hopefully approved in October. We have just decided last week that we are going to provide a technical paper. Peter is going to be involved deeply in this as well, of course. A more technical paper that is showing guidance on the technical functioning and the different categories of AI, which may be of huge help when elaborating yourself on the use of AI applications. And also, it was discussed but not yet decided if we should do a study or a questionnaire on the professional regulations in different member states regarding the use of cloud services and the use of AI applications, which then can also be used to navigate through the jungle of regulations there.
Thank you, Dominic. Thank you so much. And once again, Peter, thank you very much for your excellent, excellent presentation. We should move on to our final session so we stay within time. This is of direct relevance to everyone, which is about managing lawyers' data at a time of data scraping for training generative AI. And our speaker is Christina Radu. Christina is a member of the National Association of Romanian Bars and of the Bucharest Bar, with 17 years experience as a business lawyer specialized in data protection. She's been part of various EU projects in Romania and other European countries on the GDPR, has organized training courses on for data protection officers, and teaches personal data protection at the Romanian National Institute for Lawyers. Christina, over to you, please.
Yes, just a second. You can hear me now?
Yes.
Yes, I'm trying to share my slides. Okay. It's
They're
okay?
not quite. They've not quite come up, but they're nearly there.
Yes, it's okay now, I think.
No, no, no. I don't see them. Yes, they're there. Right,
Okay,
you're
thank
on.
you.
You're on. Okay.
Okay, well, hello all, and thank you, Jonathan, for your kind introduction. It's a pleasure to be here today with you and to see such a great number of attendants and to discuss on such a sensitive and more impactful topic, which is artificial intelligence, because we see every day, we see discussion, we see analysis of artificial intelligence, and besides the positive effect it has on our lives, we are asking ourselves from where and how does AI gather this data? Therefore, to offer such an answer from our point of view, for us lawyers, is significantly difficult because we have to build this image, this picture, from our point of view and from our professional point of view also. To offer this answer, today we are trying to analyze the implications of data scraping on our lawyers' data. And for such final end, we need to understand, to focus on some notions, some important basic notions. And I'm starting with what you are seeing on the slide. It's data scraping. And what is data scraping? Because data scraping, of course, as we all know, development, testing, and validation of AI models rely mainly on access to large data sets. And these large data sets, of course, use method for collecting such data set is data scraping. Data scraping involves the extraction of publicly available information from online sources, and generally there are two types of online data scraping. It's website scraping, which is the extraction of data from a website, such as a social media site, and screen scraping, the extraction of visual data through emulating an end user. Example, screenshots, visual images. I here recommend you for further details to read, if you have the time, of course. It's a new paper. It was issued by OECD, Organization for Economic Cooperation and Development. It was recently published in February 2025. And it is called Intellectual Property Issues in Artificial Intelligence Trained on Scale Data. And we are arriving to data mining. It's another term used, generally refers to computational processes used to identify patterns and correlations in large data sets, which are gathered through data scraping. The legal term text and data mining is commonly used by many countries in copyright laws to create limited exceptions to copyright protection. But unlike their technical definitions, the legal definition will vary from jurisdiction to jurisdiction. Data scraping can involve data collection, data preprocessing, using the data, model improvement, and/or testing evaluation. Remember, data scraping involves the use of software tools or scripts to aggregate data with minimal human intervention. It's also used to collect or make accessible large amount of data that would be impractical to aggregate manually. Therefore, it's a characteristic of scalability. Data scraping is done with no coordination between the data scraper and the entity hosting the data. And another important issue I arrived with generative AI. What is a generative AI? It is a class of AI models that imitate the structure and characteristic of AI training in order to generate derived synthetic content. Shortly, it's an AI which generates text, images, speeches, videos, or even technical inventions based on user instructions and which continues to increase in capability. It's more and more, as we all know, it's more and more present nowadays, and it is essential for organizations to understand how they can properly safeguard information online to avoid unlawful data scraping. Developers of generative AI, of course, typically rely on two main sources of data to train their models, and these are targeted source data and large-scale, large volumes of scale data. The targeted sources are characterized by their smaller size, by their well-defined parameters, their provenance can be clearly identified, and they are related usually with some licensing flavors. Most of them, of course, the payment-free use, permit free usage while potentially limiting modifications and redistribution rights. Other licenses offer larger freedoms for modifications of sharing and redistribution, but they are subject to specific license terms. And I gave these examples like Wikipedia snapshot and public domain materials, which means works that are not protected by IP rights or similar restrictions. Given the size constraints of targeted source data, I think it's easy to understand why developers go often to use the large-scale scrape data. Because the scrape data is sourced usually from loops, from websites, from blogs, from forums, from databases and social media platforms. And given all these characteristics, they have proven crucial in advancing general purpose, and they are more and more used as source for training data. So we have the scraping data. We know now that the scraped data is going to be used to train generative AI, which shall come to our lives later on. You could ask me, what's the problem? The problem is that the scraped data presents significant challenge. It raises complex IP compliance issues, especially when the origin of the scraped data is unclear, making it difficult to verify whether appropriate permissions have been secured. But please remember, web scraping is not illegal explicitly. There are no specific laws prohibiting web scraping, but web scraping isn't always welcomed by website owners because many websites, of course, discourage scraping due to concerns about intellectual property, about server overload, or data misuse. Violating terms of use can arrive to legal boundaries and can lead to cease and desist notices, blocked IPs, or even legal repercussions. Scraping often violates terms of service and copyright laws. Organizations that engage in scraping may face legal consequences, including fines and lawsuits. I gave some examples here. In the United States, for example, authors and news publishers have already sued OpenAI, Microsoft, and many others over the large language models, alleging that training processes and or their outputs involve unauthorized copying. Another case, artists and the photo aggregator have brought a claim against cloud generators such as Stability AI, and it's a well-known case, has been brought before the English court system, is the Getty Images versus Stability AI case. In that case, Getty alleges copyright and database infringement as a result of Stability downloading and storing Getty's images and the Stability AI server to train the system. This case also raises questions about the role of user input in generated images and whether these legal exceptions to infringement might apply. Recently this year, Warner Brothers Discovery has sued in September 2025 Midjourney AI for infringement of intellectual property rights, sustaining that it produces unauthorized copies of well-known characters as Superman, Bugs Bunny, and Scooby-Doo. We all know those characters. Anthropic AI has recently paid in September 2025 an amount of $1.5 billion for infringement of intellectual property rights due to a collective litigation brought by several authors whose works were scraped for training AI models. We all know now many large enterprises like Microsoft's OpenAI have been sued in various countries, not only in the US or in the English court, in respect of unauthorized scraping of copyrighted works, resulting in questions. And those questions go around which is the fair use to data mining of works in public domain. The decisions are still pending before the judiciary, but nowadays the majority legal professionals have worries about how well AI technology can protect sensitive legal data, because advanced AI models rely on large amounts of data for the training. To obtain this data, large-scale scraping of information has been undertaken, raising concerns about the potential implications for privacy and, which is more important, for data protection. A recent case has been brought to my attention. It was filed recently, in 2025. It's before the European Court of Justice. It's not yet ruled, of course. But is a request for a preliminary reading made by a Budapest, Hungary court in respect to a litigation between a company, Life Company, versus Google Online Limited. And this case is related to the responses of a chatbot based on a large language model of a partially identical response to the content of the website of the press publisher. Why this case is so important? Because this is the first AI copyright case which needs to establish the legal framework for AI's relationship with copyright and press publisher rights across the EU, and it will possibly change the way how generative AI systems can or cannot locally access, process, and reproduce protected content. In that case, from Hungary, the genuine chatbot generated a detailed summary of one of the press articles that is described a celebrity's plan to introduce dolphins to Lake Bala. When prompted by a user, genuine reproduced substantial portions of the protected content. The Budapest court, referred 4 questions to the European Court to determine whether such AI-generated responses constitute copyright infringement through unauthorized reproduction and communication to the public under EU copyright directive. Of course, the European Court has a chance to clarify the text and data mining regime under the EU application, and has been asked for questions. 2 of them concern AI training, and the other 2 address the output of the large language model. As a minor note here, the specific legal framework related to this case includes TDM exceptions in the Copyright in Digital Single Market Directive, and there have always been discussions whether these exceptions apply to the training of generative AI models at all. But we shall see in detail in 2 minutes discussions about this directive, which needs to be remembered here. European Court now, we have to decide this. We have to give this image of advanced AI training, because this is very important and we are waiting for the results. We are speaking about data protection. Of course, we cannot overrule the GDPR implications of data scraping. And the implication, as a first minor or major issue from our point of view, is data minimization. Because we have Article 5. We have Article 5 letter C, as we all know, which requires the processing of personal information to be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. Which simply to understand, but from a data scraper point of view, this is difficult, because when large scale of data are collected, the assumption that all collected information are relevant to processing, I think we all know that it's unlikely to occur. Another issue under the GDPR, lawful processing. You have Article 6, which sets out the relevant lawful basis for which entities, such as the data scraper, can process personal information. We have consent, we have contract, we have legal obligations, we have public task and vital or legitimate reasons, which are the legal basis for the legal processing of personal data. A data scraper would likely rely on the legitimate interest basis. But in 2023, Greece, Hellenic Data Protection Authority, imposed a fine of 20 million euro against Clearview AI on the grounds that did not rely on the legitimate interest basis for engaging in the large-scale scraping of facial images from the internet. Another implications under the GDPR notifying the relevant data sample. Article 14, yes, is relevant where general information is not collected directly from the data subject. We all need that. Data controller is subsequently required to inform the data subject of certain information, and such information includes identity, contact details of data controller, contact details of the relevant data protection officer, purposes of processing, relevant lawful basis for processing. There are several exceptions to this requirement, just set out in Article 14, paragraph 5, but the main relevant exception, which may be relevant to your data scraper, is that the provision of such information is impossible or would involve a disproportionate effort. This exception, although seems perfect for a data scraper to avoid, it's notoriously difficult to happen because we have a case, United Kingdom's Information Commissioner Office, ICO, has already clarified that in order to rely on this exception, the organization will need to make an assessment and document it as to whether there is a proportionate balance between the effort involved for providing the relevant notification to data subject and the impact that the processing, in our case scraping, of the personal information may have on them. To remember this as a conclusion on the GDPR implications, the mere fact that personal data is publicly accessible does not imply that the data subject has manifestly made such data public. There has to be an understanding from the data subject and an affirmative action on data subject's part indicate this. And we arrive to AI Act implications. Now, the European Union has two key instruments to address copyright issues related to AI. The Directive on Copyright and Related Rights in the Digital Single Market and the European Union Artificial Intelligence Act. Directive introduces two exceptions that allow the use of particular words or TDM activity for text and data handling activities under certain conditions. We have Article 4, which allows TDM of lawfully accessible words for commercial and non-commercial purposes, provided the entity has legal access to licenses or public availability. However, remember this, rights holders can opt out of this duty via contracts, declarations, machine readable minutes, or terms and conditions. This opt-out only applies if right holders reserve the right against that duty. On the other hand, we have Article 3, which comes to non-commercial carve-out to the general TDM authority, and it allows research organizations and cultural heritage institutions to conduct text and data mining for scientific purposes. Unlike the exception set out in the previous article Article 4, now copyright holders cannot override or opt out of this exception by any constructive or technical reason. And we have been provided with European Union Artificial Intelligence Act, APLIT, which comes and supports the directive by focusing on the responsibilities of providers of general purpose AI models, because it requires the providers to implement the policy to comply with copyright and related laws, because providers are required to draw up and make publicly available a sufficiently detailed summary about the content used for training of the general purpose AI model. Also, it expressly has interdiction considers the untargeted scraping of online fashion images to constitute an acceptable threat to fundamental rights and freedom. So we have under the Artificial Intelligence Act prohibited as a prohibited AI practice. It's placing on the market the creativity service for this specific purpose or the use of AI systems that create or expand facial recognition databases through the untargeted scraping of facial images from the internet or CCTV footage. To remember the implication of data scraping under the AI Act, it introduces compliance obligations for providers of general purpose AI models, requiring them to implement policies that align with EU copyright laws, including the use of state-of-the-art technologies to identify copyrighted work and comply with the TDM opt-out mechanisms established in directive. Because providers of general purpose must also publish or disclose detailed summaries about the datasets used for training. To support implementation, a general purpose AI code of practice was recently published in July 2025, which aims to provide guidance on transparency and copyright-related obligations. So we've seen the major important notions. We have seen the implication of the GDPR and the AI Act, and we arrive now on our main result, implications on our lawyers' data. because we have seen on the first presentation of Dominic how important is confidentiality for our profession. So lawyers' ethical obligations regarding confidentiality of client information make proper data protection essential. But many law firms are currently unprepared to address AI-related things because lawyers need to attend to the risks that arise when implementing new technology, and we all are always aware risks related to unauthorized information disclosure to legitimate third parties are widely unidentified or underestimated. Because even if a law firm does not use specific generative AI tools, solutions, their data, including work product and client information, may be used by third parties for unauthorized or unexpected purposes, such as commercial love language model training. Because also from practice, some vendors usually desperate for high training data are adapting the terms of service, terms of use, by playing with semantics to make them as ambiguously as possible to extrapolate the permitted use of customer data for training of LLM models. Protection of a law firm's data in this era, in this generative AI era, implies ongoing attention to data management and implementing at least some minor activities. This were gathered from practice, and the first one, it's easy to understand because it's similar to the GDPR, data inventory program. Because we need to make an up-to-date inventory of technology vendors with access to law firm data and the current terms of service, because we are using Google Workspace, customer relationship management, Google Translate, online grammar correction software, etc., which can seem safe, it can seem innocent at first glance, but may pose a hidden risk if used by law firms' employees or consultants when processing legal documents, because their content may end up in a place where it should never be. Also, another aspect, data minimization strategy. I think we all know it from the GDPR, because now, for data scraping, we need to document what data law firm stores and processes, for what purposes, and where and how that information can be captured in a corporate data management program. Any data that must be preserved but is not required daily, if they so, can be, of course, sent to the storages, and it can be later be retrieved if necessary. Another issue, inventory of all parties with access to firm data under data protection agreements. It's easy to understand here to establish separate data protection agreements with all external parties that have access to a reference data, prohibiting any unauthorized use of the data. We all have our cybersecurity vendors like that can scan a phone laptop and can send to the cloud any document with no knowledge for us. It is essential to minimize the number of third-party data processing vendors and carefully review the terms of service agreed that we made. Because we need to anonymize any data that we submit for external processing. Data confidentiality also should be present on law firms trusted third parties that, of course, have legitimate access to firm data and a proper data protection agreement. And this principle is already known and used under the data protection generally, and especially under the GDPR, because whenever we share sensitive data with any third party, we need to give preference to the ones with mature data protection, with a security management plan. Cloud security and authorized cloud use policies, of course, we need to maintain an inventory of our cloud data and cloud resources, to have those resources regularly tested by cloud security providers for possible misconfiguration, for possible weaknesses. Authorized user priorities. We all happen to find out in our practice until now that human error is majorly, not mainly, but is the majorly part of the majorly cause for GDPR. This is the main issue with data scraping, because the human error while using AI is the most general cause of data. And here a simple example, a lawyer that can upload a confidential document on an online platform to get summary of it. This is a problem because it is crucial to create a wide use case. And also the protection of public data, because we all know that we as lawyers are very generous with our data. We upload our knowledge on our website, and we need to review those law firms' website constantly. We can add more than article.
Christina, I'm going to stop you. This is reluctant to stop you. Fascinating, very useful advice. I know it's all in the slides, and I really would recommend people to go to your slides because every detail is there, perfect. But we really should end on time because people are already leaving the session. So thank you so much for your excellent presentation.
Thank you also, and you have all my slides.
Exactly, the slides will be uploaded. Everybody's slides, not just Christina's slides. She has a few more. She's nearly at the end. She has a few more. The detail is all there, so you can at the end of today. It'll be on the foundation website, as with all the other slides. I'd like to thank all our speakers very much indeed for their excellent presentations. Very useful. You can see in the chat many people are putting very nice comments. And I'd also like to thank you, the participants, for your participation. We look forward to seeing you at our next webinar. You will see, if you follow either the European Lawyers Foundation or the CCBE on social media, you'll see when it is. Thank you very much, everybody. That's the end of the webinar. Thank you and goodbye to everybody.
Thank you, Jonathan. Bye.
Thank you. Goodbye.
Thank you. Bye.
Thank you.